So as most of you know, these cases involve the Affordable Care Act's contraception mandate, which requires that employers who provide health care to their employees provide no-cost contraception coverage. And this has spurred many lawsuits from companies. Well, backing up a little bit, that the law has an exemption for religious employers like churches, and also has an opt-out provision for some nonprofit employers, which is the subject of separate litigation that's ongoing as well. But in this case, we're talking about for-profit companies who have filed suits saying that by forcing them to provide certain contraception measures, which they consider, per their religious practice, to be tantamount to abortion, that is violating their rights under the Religious Freedom Restoration Act. The government, on the other hand, says that I'll call it RFRA, if that's okay with everybody. It's easier to say than the full thing. That RFRA does not apply to for-profit companies because they don't have religious rights. And even if it did, that the strict scrutiny standard that RFRA applies can be met to meet the compelling interest of protecting the reproductive rights of women and not unduly burdening them with the cost that would be unfairly placed upon them if these measures are not covered. So it's sort of a battle of sorts, right, between the protecting reproductive rights on one hand and the protecting religious rights on the other. And we'll kick it off with Walter to talk a little bit about the reproductive rights aspect of this.
Thank you. It was for a very good reason that the Federal Centers for Disease Control listed improvements in family planning as one of the 10 great public health achievements of the 20th century. It has had an enormous effect on the lives of women and their families, on their health, on their well-being, and on their ability to participate fully in the society. So that the brief that I did on behalf of the Guttmacher Institute, which has, I guess I'll stand up so I can see folks. I did a brief on behalf of the Guttmacher Institute, which has for the last 4 decades been the leading source of studies and information and data on sexual and reproductive health. And Susan Cohen is here today, my client. But what is critically important about this case is that the role of contraception comes into play at 2 different points in the analysis. As Kim said, the issue in this case is whether the inclusion of contraceptive coverage among the other preventive services that are part of the package that health insurance companies must offer imposes a substantial burden on the religion of a closely held company that objects to having insurance plans for its employees under which the employee may choose to use contraception and have it reimbursed. If it is a substantial burden, it can be justified if the government can show there's a compelling governmental interest, and there's no less restrictive way of achieving that interest. So obviously, the importance of contraception plays a role in determining at the end of the case whether there might be a compelling governmental interest. But it also plays a very critical role in determining what is a legally cognizable substantial burden on religion. Because however logically you would think that is simply a matter for the religious group itself, the court has held repeatedly that in determining whether you can call something a cognizable substantial burden, one critical factor is whether accommodating that religious position is going to transfer a burden to third parties. The court has said that repeatedly in United States versus Lee, in Calder versus Thornton, and in other cases. And so one of the principal functions of this brief is to show that there is a significant burden that is transferred to third parties. It's very different to give a religious group an exemption from a law of general applicability. You know, nobody may use peyote, but if it's a sacrament in your church, you get to use peyote. It's different if you're transferring a burden to third parties. And so the burden of this brief is to show that. Now, I think a central claim made by those defending the position of Conestoga Wood's and Hobby Lobby, the two companies in the two cases, is that this really isn't a very important or significant burden that's being imposed. Because in their central assertion that 89% of women who want to avoid pregnancy are already using contraception. And if you stop at that point, it's sort of a gratuitous burden on the religious views of those who have them. That misses two critical points. One, there's millions of women who don't have access to contraception and wish they did. But much more important than that, and absolutely critical to the case and critical to the provision, is that women lack affordable access to the most effective means of contraception. This brief was sort of like the brief I worked on in Lawrence against Texas, where we were trying to present the picture of the gay and lesbian communities to the court so they would understand, what those communities are like. This is to try to provide the court some sense of the role of contraception. You can't just say 89% of women have contraception, because the critical importance of the federal requirement is that it provides women access to the full range of contraceptive methods without fees or cost sharing. Why is that important? It is what the Guttmacher data shows is that there are vast differences in the effectiveness of different methods of contraception, far more than most of us would realize. An IUD is 45 times more effective than oral contraception. 45 times, 90 times more effective than the use of the male condom. And cost is a significant factor in determining what contraceptive methods women are able to use. Almost 1/3 of American women report that they would use a different method of contraception if costs were not a factor. IUDs can cost $1,000 up front. Whether that's a big number for the people in this room is one thing, but that is 1 month's salary for a full-time worker employed at the minimum wage. And the studies show that having access without upfront costs to more effective means of contraception dramatically reduces the rate of unintended pregnancy and dramatically reduces the number of abortions. So that I won't go through into the discussion other aspects of why this is so critically important to impose the range, and not have women not know whether their employer at any point in time is going to object to other methods or not. But the critical fact here is that the burden being transferred is not just an economic burden, it's also a moral burden. Effective contraception is the most effective means of reducing the number of abortions. I mean, consider the fact of an employee who might have moral concerns about abortion but not object to these methods of contraception. A mother of 3 has health needs or economic needs to avoid another pregnancy. Denying her access to the most effective means of contraception could place her in a moral dilemma for her that she would not wish to be in. So this is a very dramatic transfer from the very indirect burden imposed on companies who wish to have health insurance and don't want it to have this kind of coverage, to the individual who has her own moral and religious beliefs. So I will just close by noting that what this really does is to put the employer literally in the examiner, almost literally, in the examination room with a woman and her doctor, going through the checklist as, does this employer object to implantable devices? Does this employer object to IUDs? How about Ella? How about Plan B? You can't just have the patient and the physician determine what's best for the patient without the employer interposing it. And that seems to me to be a fundamentally wrong extension of what we think of when we think of liberty.
On the other side, we have the issue of religious freedom and the free exercise right of individuals who own private companies. And Kevin, can you start us off on the discussion about that side of the coin?
Sure. Let me start by saying I don't think the issue in this case is whether or not women will have access to free contraceptives, because under Obamacare, any employee of a religiously accommodated employer still gets those services with a guarantee that she will not have to pay for them. So the question isn't whether these employees will bear the cost. The question is whether or not there's any free exercise right at all in this case. That's the interesting question, I think, does Hobby Lobby have any free exercise rights at all? And that's the question we address in our brief. I don't know whether our brief is one of the two that's out there available to you, but you can probably find it in the Supreme Court's docket. Here's the question. If the Greens, who founded Hobby Lobby, which among other things runs a Christian bookstore and requires all owners of the company to sign a pledge that they will operate the company in accordance with their Christian beliefs, if they had decided to open up a sole proprietorship, there's no question they would at least be able to assert a free exercise interest. And I think if they had formed a corporation, a partnership among 2 or 3 family members, there'd be no question they'd be able to assert a free exercise interest. Whether or not they win the case at the end is another matter. But the question in this case is whether an individual who clearly has personal free exercise interests, him or herself, forfeits those rights altogether by deciding to operate his or her business in the form of a corporation. The position we take is simply this. When you go to the state and say, I want to incorporate, I want to take advantage of the limited liability that incorporation affords, the state doesn't really say to you, well, okay, that's fine, but if you're going to incorporate as a for-profit, you can't have any religious ideas. You can't have any religious purposes as well, and you can't have any religious principles that are going to guide you, because you basically have to sign a paper saying we waive any free exercise rights we have to operate our business in accordance with our religious beliefs by incorporating. Now, no state says that, and I don't think Congress implicitly said that when it passed the Religious Freedom Restoration Act. And so the first threshold question, which is really the interesting legal question, is whether or not Hobby Lobby, or, as we maintain, its owners, the individuals who own, found, and operate that business as a closely held family corporation that espouses religious values, whether they have any rights at all to say, we object, we have a religious interest here. And then if they do, then it's fair to ask Walter's questions. Is the burden on religion a substantial one? Is it overcome by a compelling governmental interest? Those are fair questions to ask, and they're debatable propositions. But the first and most interesting question, what makes this case, I think, worth following primarily, is whether or not the court will say that either the company or the individuals who founded and owned the company in part for religious purposes can raise a religious objection at all, or whether they're cut off at the knees, complaint dismissed, you cannot assert a claim. We think they have a claim, and then the case gets interesting.
Then continuing on with the issue of the religious right of corporations, Carolyn, you want to jump in?
Yeah. So there are 2 types of plaintiffs in these contraception mandate cases. First, there are for-profit corporations who claim that the contraception mandate violates the corporation's religious liberties. And second, there are the owners of the corporations who argue that the contraception mandate violates their individual religious rights. And both plaintiffs should lose, but for different reasons. The corporations should lose because for-profit corporations do not and should not have religious rights. And the owners of the corporation should lose because their claims have no merit. So starting with the corporations, the reasons we protect individuals and churches with religious freedom simply don't apply to for-profit corporations. So why do we protect individual religious conscience? Well, religiously inclined people would say we protect individual religious conscience so people can fulfill their obligations to God. Right? Failure to do so would cause great suffering, both here and in the hereafter. Right? Corporations, of course, cannot suffer. They are not sentient, they have no soul, and they certainly don't have a relationship with God. Secular people might say, well, we protect religious conscience and people's decisions about their spirituality because it's a way of respecting people's individual autonomy and inherent dignity. But while people are an end to themselves and have inviolable dignity, corporations do not. Right? They are merely a means to an end. They don't possess any inherent dignity that we have to respect. So, in short, religious protection only makes sense when applied to actual people. Corporations lack the fundamentally human attributes, whether it's relationship with God or inviolable dignity, that justify religious liberty. And as for churches, actually there's quite a lot of debate about whether churches have protection as churches as opposed to an association of individuals. But assuming that there is protection for churches as churches, we protect them because they're sacred houses of God. They're the source of theological truth. They are institutions whose overriding mission is religious, and they're voluntary religious associations. A chain of arts and crafts stores are none of those things. So the reasons we protect religious liberty simply do not apply to corporations. Now, the corporation's owners, as actual living human beings, can of course bring claims. However, there are any number of reasons why their claims should fail. Right? And just for the moment, focusing on whether there's a substantial burden on their individual religious conscience. First, there's actually, to a large extent, no clash between their legal and religious obligations. The two families in this case aren't actually opposed to contraception. They're opposed to abortion. And they object to the contraception mandate in large part because it covers morning after pills, which they believe kill fertilized eggs and therefore amounts to an abortion in violation of their religious beliefs. But they're wrong. The science is in, and all reputable studies show that these pills work by preventing ovulation. Right? There is no killing of fertilized eggs because there are no eggs. The pills prevent ovulation. So everyone's entitled to their religious beliefs, but not everyone is entitled to their own set of facts. And the facts here show that there's not a clash between legal and religious obligation vis-a-vis the morning after pills. Second, the contraception mandate does not require the members of these families, like the Green family and Hobby Lobby, to do anything. Rather, it requires their corporation, a legally distinct entity, to provide insurance. Actually, it's even one step more removed for Hobby Lobby because the family doesn't own the company directly. It's actually owned by a trust of which they are the beneficiary. So they're the beneficiaries of a trust of a corporation whose insurance company provides contraception that their employees might use. All right, but setting aside the trust issue, right, presumably they incorporated to take advantage of limited liability. Right? Incorporation ensures that the company's debts are not their personal debts. But then to turn around and argue that the company's spending is really their personal spending simply smacks of having their cake and eating it too. Third, the burden is too attenuated to amount to a substantial burden. Right? No one in these families has to take contraception. They don't have to give it to anyone. They don't have to pay for it. Right? Their argument essentially boils down to the claim that facilitating other people's contraception use violates their religious conscience. But paying a decent salary also facilitates contraception use. Does that mean employers may be exempt from minimum wage laws? Does that mean they have a right to condition how their employees spend their salary? And that analogy actually isn't far off, since health insurance is part of employees' compensation. But the bottom line is, at some point, the claim is simply too attenuated to amount to a substantial burden. And the claim here is far past that point. So the last thing I want to say is that granting employers exemptions not only exacerbates the power imbalance between employers and employees, but it really risks making religious liberty yet another luxury reserved for those at the top.
So you have these two competing interests on either side, and there is the issue of the shifting of burdens, financial and otherwise. So Fred, can you talk a little bit about that cost shifting aspect of this case?
Yes, the claimants in these cases, Hobby Lobby, Conestoga Wood, and their owners, talk a lot about religious liberty. And religious liberty is an obvious and an important aspect of personal freedom in the United States. Beyond what the Constitution or the Free Exercise Clause demands, I personally think we ought to give individuals as much space as we can to live out their religious beliefs, to live their lives in accordance with their religious beliefs. But that space, the accommodations that we make, has to have some limits. We live in a broadly pluralistic society. Every decade, there are more and more religions, more and more iterations of existing religions, more and more people who are not religious at all. And it's inevitable that if we try, that in accommodating religious belief, that it's going to intrude upon the interests of others. If you give somebody Sunday off because it's their day of worship, or Saturday or Friday, then somebody has to work in their place. If you happen to be the only unbeliever, or the only Jew, or the only Muslim in a heavily Christian area, and all the Christian employees are given Sunday off, then you're going to be working every Sunday. It's not fun to be bearing the costs of the religious practices of others. Now, the government shifts costs around all the time. It taxes things. It exempts other activities. It incentivizes activities. It disincentivizes activities. It penalizes some activities. It promotes others. We couldn't have a graduated income tax, for example, if the government could never impose costs on others for the benefit of certain people. But when it comes to religious activity under the Constitution, that's a special case. The Establishment Clause does not permit the government to impose the costs of practicing a religion on others who don't believe in or participate or belong to that religion. And there's a reason for that. And like so many other things, it goes back to the 18th century and the views of the framers. The classic violation that the framers were concerned about, the classic violation of liberty that the Establishment Clause was meant to address, was the state-favored or established church that taxed everybody to support it, even people who weren't members, who penalized people who weren't members because in order to promote the church, that imposed penalties and burdens on individuals for not belonging to the church. So when you think about that against REFRA exemptions from the contraception mandate, the two situations are actually quite close. REFRA exemptions would deprive employees of a statutory entitlement, federally mandated insurance coverage, for the sole purpose of facilitating the employer's belief. That is, employees who don't belong to the employer's religion, who do not share his beliefs or his practices, nevertheless are required to bear the burdens of those practices. That violates the Establishment Clause, and I can think of no constitutional principle that requires individuals to bear the costs of of living somebody else's religion. The law already implicitly recognizes this. So consider, for example, Title VII. One of the most important federal statutes that we have, which prohibits a wide variety of discrimination in employment, including religious discrimination. Now, there is a section of Title VII which requires employers to accommodate employee religious beliefs. But the employers are only required to do so if the accommodations, if the costs of the accommodations are trivial, are de minimis, are insignificant. And you can see why that makes sense. If employees had an absolute right to accommodation against their employers, then just the administrative costs would be complicated. Just getting people to fill shifts would be difficult. The employer would be having to offer overtime and premium pay. Collective bargaining agreements would have to be violated in order to accommodate the wide variety of religious claims that would be made by employees. So employees are entitled to accommodation only if the accommodation imposes insignificant costs on the employers. If RFRA exemptions are granted to the contraception mandate, then that creates a really serious asymmetry, imbalance between the protection of employer religion and employee religion. Hobby Lobby and Conestoga Wood want their religion, their religious beliefs and practices protected at the expense of their employees. As Walter has pointed out, that expense and that burden is significant. And yet, the employees could not maintain the same sort of claim against their employers. Employees are entitled to accommodation of their religion only if the costs are insignificant. And I can think of no principle, no constitutional principle, no moral or ethical principle which suggests that employer religion is entitled to greater protection than employee religion.
So this case, the first issue that these cases present is the issue of what constitutes a person, right? And under the First Amendment for Establishment Clause purposes, we had a similar issue like this when it came to free speech rights with Citizens United. How easy or difficult will it be to extend that principle from free speech rights to free exercise rights? And what role does Citizens United play here? Do you want to start out, Caroline?
Yeah, I do. Yeah, you very often hear the argument that, well, since the Supreme Court has extended free speech rights under the First Amendment, it naturally follows that corporations have free exercise rights under the First Amendment. But actually, it doesn't follow at all. So the reason why Citizens United, or the better case is really Bellotti. The reason why the Supreme Court protected corporate speech was not for the benefit of the corporate speakers. It was the benefit. It was for the benefit of audiences. Right? The idea is we protect speech in part to ensure a free flow of information, including speech from corporations. And so let me give you this example. Imagine that there's a computer and it has data. It can generate all kinds of interesting information for an upcoming election. Right? The Supreme Court's conclusion that the government can't censor that speech is not because computers have a right to speak. It's because citizens have the right to that politically relevant information. Right? So this protection for corporate speech was extended on a theory of protecting speech for audiences. And there's really no counterpart for that audience-focused protection in free exercise.
I think it's a tougher case than Carolyn does. I mean, I think her arguments are persuasive, but and I think that corporations claiming free exercise exemptions from generally applicable neutral laws should almost always lose for reasons that have to do with the analysis about what constitutes a substantial burden and transferring cost. But I'm not sure that it makes sense to bar them at the front door of getting into the courthouse to make the assertion. If a state required every corporation in the state to put a crucifix on all of their products, I don't know why a corporation couldn't assert some right that that was a religious infringement. I mean, there is one sense in which they're different. You don't have to believe in the cause that you're putting forth as a speaker. That is, if the National Review had run Martin Luther King's "Heed Their Rising Voices" ad, they would have been, even if they didn't agree with it, they would have been as entitled to First Amendment protection as the New York Times. If I bought Fox News, I'd still be entitled to First Amendment protection for speech that I didn't even agree with if someone tried to censor it. But in a religious thing, you have to have a religious burden. I think for the reasons Carolyn put forward very powerfully, it's hard to see what the burden is. I think that this corporate issue is vastly overrated in this case, however. Because I strongly doubt, it has attracted the most attention. I strongly doubt that the court will even reach it. It poses a whole tangle of practical applications. Even if you agree with corporations can do it, what happens if I buy a 40% controlling share in Hobby Lobby? Can I still claim the exemption if I don't agree with the argument? But I think the fact that the Green family and the Hahn family in the two cases, while the burden is not imposed upon them, the court, I believe, is going to accept their argument that they have, as managers of the company, they have a burden imposed upon them. I think they can assert that burden. The court's going to recognize that they can assert that burden and say, we did not reach the question of whether the corporations could. Now, if that's the most overrated issue in the case, the most underrated issue is the issue that Professor Martin Lederman keeps raising. It's like the standing issue in Perry versus Hollingsworth, where I was the lonely voice for years saying there's no standing here. I think far more attention is going to be paid to the question of whether there is such a thing as an employer mandate. That's the underrated issue that no one is interested in. There is no employer mandate. It's a myth. You do not have to provide health insurance for your employees. Unlike the individual mandate, where there was a freestanding requirement that individuals have coverage for themselves and their family and pay a penalty if they didn't, there is no underlying requirement. This is an obligation. The coverage obligations imposed upon insurance companies, whether in the private market or doing corporate insurance employment policies, these are the minimum requirements of a policy. That's not a novel idea. 28 states have requirements of some form of contraception to be part of insurance coverage. And the employer can choose not to have health insurance coverage and pay an assessment for not into a fund to help the fund general coverage for individuals, where no one disputes that the cost of that is less than the cost of providing health insurance that meets the minimum standards. So companies are financially better off. They say vaguely that, well, it would be a competitive disadvantage not to offer health insurance, is how the companies respond to this. But there's nothing in their pleadings that would satisfy this court's stringent requirements in Iqbal and Twombly to pleadings cases that you plead very specifically how that is a burden. Why can't you simply avoid the problem by not offering health insurance and use all the money that you save to give higher compensation where employees can go into the market and buy their own subsidized policy? There is no, and that sort of changes the dynamic where the company says, well, we're not actually forced to do this, but we'd rather offer health insurance. And if we do, we get into a situation where we believe we're morally complicit. That is going to attract a lot of attention and a lot of questioning from the court, more so than the much more heralded corporate issue, where I think Kevin's brief makes some pretty persuasive points. This is not a new issue. Companies in corporate form have asserted First Amendment rights, free exercise rights, in other cases, right? Fred, you know these cases better, and Kevin, this would not be a novel proposition. It would be the first time, I think, a for-profit corporation had asserted rights, but non-individual assertions have some lineage that greatly predates Citizens United.
Do you
Is that
agree
right?
that this is the overplayed
I
issue?
think that's right, and if you read Michael McConnell's brief, amicus brief in the Supreme Court, he does the best job of laying out the history and how the history supports the proposition that a for-profit corporation can assert free exercise rights. He takes a slightly different view than we do. As I said, our view really is, especially a closely held family corporation, which is founded on religious principles, that the individuals who really run and control the corporation don't waive their rights by taking advantage of limited liability. The state does intend to limit liability, but it doesn't intend to limit those individuals' personal freedom. And if they can make a showing, and this is not Exxon or Mobil or Apple or Google, and there probably aren't a whole lot of corporations who can make the showing, but if you can make the showing, you ought to at least be able to raise the question whether or not they meet the test of a substantial burden, whether there's a compelling governmental interest on the other side. Let me just address for a moment Fred's point about placing the burden on the employees, because I understand if not the constitutional force of that, the practical force of that argument. As a practical matter, the cost of accommodating Hobby Lobby's employees will not be borne by the employees. It is the likely outcome, if they were to win the case completely, the likely outcome is that these employees will be fully covered for all contraceptive services at the expense of either the insurance company or the government. That's the way the accommodation works under the Affordable Health Care Act. Even if that weren't the case, it would not violate the Establishment Clause or deny any employees religious liberty, even if the costs were borne by them, which they would not be. That is the way the exemption works under the statute. Employers who are classified as religious employers are exempt altogether. The employees of those organizations, and there are hundreds and thousands, if not millions of those employees, don't get the coverage at all. Nobody pays for their coverage. They have to pay for it themselves. So if it's an Establishment Clause problem to accommodate a religious employer and shift the burden to employees, well, then the religious employer exemption of Obamacare is unconstitutional. And I'd be curious to know Fred's response to that. But there is no free exercise right here that could be asserted by the employees. Yes, there are constitutional rights to reproductive freedom, no question about it. But there is no constitutional right to have the government subsidize your contraception, much less to have a private person subsidize your contraception. The Supreme Court came within one vote of saying that the government couldn't force any employer to provide health insurance at all for their employees. Do you really think the Supreme Court would say it's an Establishment Clause violation to exempt an employer on religious grounds? I just can't in my wildest dreams imagine that would be taken as a colorable Establishment Clause problem. So you kind of get to the question, I think, of compelling governmental interest. And here's the government's biggest problem in arguing to the Supreme Court there's a compelling governmental interest overcoming any religious freedom interest that may exist. The government has already made a judgment in two respects, that it does not want to enforce the contraceptive mandate over the objection of a sincerely held religious position. It has exempted religious employers altogether, leaving their employees without any benefits in this area. And secondly, it has said, if you're not an exempt religious employer, but you come under the accommodation for employers who have some relationship to a religious institution, like, for example, Georgetown University as one example, other universities that have affiliations with some religious denomination, those employers are accommodated, which means the employees don't get the coverage from the employer. So in those two respects, the government has made a determination that when we see on the one hand the interest in contraceptive access, and on the other hand a sincerely held religious objection, the government consistently has said, we don't assert an overriding compelling interest to overcome the religious objection. The government's just saying we don't see any religious issue here. If the Supreme Court says there's a religious issue, then the government's over there in the area in which they have said, fine, we accommodate you. So I don't really see a compelling governmental interest given the concessions the government implicitly has made on 2 occasions that they do not want the access to contraceptive interests to trump genuinely, sincerely held religious beliefs.
Well, we have
a factual problem.
Let me respond to Kevin.
Go ahead.
Direct this to me.
We all want to respond to Kevin.
It is 3-1 in case you haven't noticed. Except that I welcome Walter's concession on one point. It's at least 2-2. And I'd be interested in your view about that. Is there any religious freedom interest at all?
Well, Kevin, you asked about 15 questions. Let me just respond to what I think is the most important one. Hobby Lobby is an arts and crafts chain. Conestoga Wood is a cabinet manufacturer. I think it really stretches things to compare them to churches. To say that Hobby Lobby is a religious organization, I think, is to turn language on its head. We have in the United States a long tradition of accommodating churches and religious organizations, religious universities, religious nonprofit hospitals. The idea that someone can designate their for-profit corporation as a religious organization and then step into that tradition as if they were no different, as if their arts and crafts store were no different from the Roman Catholic Church, I find it both absurd and a little insulting. I'm a religious person. And I think that my tradition is different than an arts and crafts store, and that the differences are real, that they're not formal or technical. Now, I think Kevin is also operating under a misconception of how the Affordable Care Act and the contraception mandate works. There is an accommodation for religious nonprofit organizations. There is no accommodation for religious for-profit organizations. So if Hobby Lobby receives a REFRA exemption, the employees will not receive contraceptives without cost sharing from their plan administrator or from their insurer. They will have to take their after-tax wages and buy them. And I think Walter's brief and Walter's presentation here indicates that that is a significant burden. Even if it were not a huge burden. I mean, it's always interesting to decide how much money is significant. You know, it depends on how much you're making. But I do not understand why anyone should have to pay anything to fund someone else's practice of their religion. That is an aspect of religious liberty. It's not a free exercise claim, but we have an establishment clause precisely because the framers did not want the population and citizens of the United States to bear the costs of practicing someone else's religion. That is exactly what would be happening here. As far as the fact that since there's an accommodation for religious nonprofits, since there's an exemption for churches, well then what's the difference? If we have those exemptions, then it's simply a kind of bad faith not to extend those exemptions to Hobby Lobby and other for-profit corporations. That doesn't follow at all. If you're going to work for the Archdiocese of Chicago, if you're going to work for the Church of Jesus Christ of Latter-day Saints in Salt Lake City, number one, it's overwhelmingly likely, as the government itself found when it issued the regulations, that you're going to share the beliefs of your employer. But even if you don't, there are powerful expressive interests by that the Archdiocese of Chicago has, that the Church of Jesus Christ of Latter-day Saints have, in expressing their religious mission. if you oppose the use of contraceptives and you are a church, then requiring you to supply the very contraceptives that you designate as wrong or immoral obviously muddles your mission. It compromises your ability to express your religious message. But there is no religious message being expressed by Hobby Lobby's arts and crafts store. Now, I don't want to denigrate the sincerity of the Greens or the owners of Conestoga Wood and their desire to implement or express their religion through their business. But just because someone subjectively feels like they're expressing a message by selling glue and crepe paper doesn't mean that everyone else who walks into the store is going to understand, yes, this is an expression of Mr. Green's religious beliefs. For-profit corporations have weak, if any, expressive interests.
Well, can I ask this question? I mean, on the RFRA analysis itself, the fact that for the religious employers, there is this exemption. Doesn't that sort of deal a double blow to the government's case? One, it seems an admission that there is an employer can have a religious belief, right, if you're giving exemptions to others. And B, on the strict scrutiny analysis, that there is a less restrictive means of meeting the proffered goal of the law.
Good question. First of all, when Kevin speaks of the religious interest of the owners of Hobby Lobby, be very clear about this. That is not a limitation being advanced by Conestoga Woods and Hobby Lobby and the Supreme Court. They're not saying that, they're not seeking a ruling that is limited to companies that close on Sundays and manifest religious view. Their view is that all all closely held for-profit corporations are entitled to assert this exemption. Those are not necessarily mom and pop stores. There are for-profit closely held corporations that have over $100 billion in revenue and more than 100,000 employees in the country that this principle would extend to, as well as to Hobby Lobby. The fact that we have, in order to assert a compelling governmental interest, the government has to assert that its law is neutral and of general applicability. So it's not gerrymandered in a way that is hostile to religious groups. No one is asserting that here. This is unlike the ban on the religious use of animal sacrifice in the Santa Rita case, where the state of Florida made it a constitutional right to kill animals, unless you were doing it for religious purposes. So I don't think the fact that we're recognizing an exemption for churches and have an accommodation for religious organizations whereby their insurance company can provide it is going to see this undercutting the government's interest in having contraception widely available and in the most effective means. It is just not the case. One thing that I want to be very clear about, the women who are employed by these companies, if they win this case, they don't have any coverage for their contraception, period. There is none. There is no subsidy. There is no coverage. They have insurance policies. And in fact, every woman will have to consult her employer's religious ideas in order to decide with her doctor what's on the checklist of approved or non-approved methods of contraception. The doctor say, I think in your case, you really need to use an implantable device because of the risk to your health of a pregnancy. You need something that is far more effective than oral contraceptives or whatever. And they say, well, we got to check and see whether my employer now objects to this method. I believe that they're entitled to assert an objection, whether it's good science or not. But the only small point of difference I have with Carolyn. But it's the one other notion is that free contraception is being, that this is a claim that women want free contraception. if not from Uncle Sugar, as Governor Huckabee put it, from their employer. That's just a fundamentally wrong way to look at it. This is part of a compensation package that people have earned through their employment. It's an employment benefit as part of federal law, just as fully as the minimum wage, Social Security benefits, Medicare coverage, contributions from the employer. This is a benefit that women earn, or that women and men earn for their dependents who are using contraceptions through their health care program. There's nothing sort of free about this. Lastly, in terms of whether or not the government can simply extend the accommodation they make for religiously affiliated non-church companies, they're not going to argue this because the people, the coalition bringing this challenge, they believe that's unconstitutional as well. That's the Notre Dame case. They believe that's unconstitutional, and it's just not the same thing to say to people who get across-the-board health insurance coverage from their employer, oh, by the way, you're now on your own. Go out into the market and find your own insurance policy, and we're going to require the government to subsidize it. That can't be the answer in every case that the government subsidizes.
One other little point that I would like to make is that basically, if there is an exemption for not just the morning after pills and IUDs, but contraception as well. Basically, what you have is a government-mandated health insurance program that covers men's basic preventive care, but not women's basic preventive care. Because let's be clear, contraception is something that only women use and just about every woman uses. So it would also amount to a very straightforward sex discrimination problem. And surely avoiding sex discrimination in the provision of basic health care is a compelling government interest. And in fact, the only reason why this kind of program wouldn't raise an equal protection challenge is because 6 men somehow managed to convince themselves that pregnancy discrimination was not sex discrimination under the Equal Protection Clause. That's a Supreme Court case, by the way.
But you make a compelling argument for the inclusion of these services as a policy matter. I'm not questioning that. But the idea that it's unlawful sex discrimination would apply equally to the existing exemptions in the law. I mean, if it's impermissible sex discrimination, then Obamacare is unlawful because it accommodates these religious institutions in these 2 different ways. Now, Walter's correct that the regulation as written does not extend the accommodation to these employers. But what you see with the Affordable Care Act is a constant reshuffling and rejiggering to kind of try to get it right. And they clearly haven't gotten it right, the first time they drafted it or the second time they drafted it. But what's happened is, and this particular issue in particular, what's happened is there was an uproar over what happened to employers that didn't meet the very, very strict definition of religious employer. I mean, it left all sorts. It left Catholic Charities of the Archdiocese of Washington outside the exemption, which is, if you can have an exemption, doesn't seem exactly right. So it required a lot of kind of back and forth between the administration and religious organization. And the administration said, you know what, yeah, you're right. We need to fix this. So we're going to fix it, just as they fixed all sorts of other things. And I guess what I'm saying is, in the real world here, there's really not a shadow of a doubt that if Hobby Lobby were to win this case, you'd have the administration the next day saying, oh, well, there's now a need to expand that accommodation. It's not in the books right now, you're absolutely right. But if you're trying to ask yourself what's the right answer to all of this, that's clearly the outcome.
Well, here's U.S. versus Lee. U.S. versus Lee, an Amish employer believes that Social Security is immoral and doesn't want to pay the required FICA taxes, right? He loses 9-0. The court says once you enter into the world of business, you're entitled to your own beliefs. You're not entitled to exemptions to the laws that apply to all others. They also add, certainly when the burden would be imposed upon your employees who would lack the Social Security contributions. But if you're right that simply having the government step up and pay for contraceptions is the answer, it would have been the answer in U.S. versus Lee. The government could just say, well, in those cases, we'll pay for the Social Security contributions. The government will pay for it. Nobody thought that that was the answer, that you can, I think if you go through every single, I'd like to do the exercise of going through every single lower court case where the court has rejected a religious accommodation, where there could have been a less restrictive alternative, but the government just paying for it, holding everybody harmless. So I just don't think that could possibly be the answer given the case law.
Let me just respond to U.S. versus Lee, because I know you relied upon that in your brief and caused me to go back and ask what U.S. versus Lee was. In that case, the government did recognize, the court did recognize that compelling participation in the Social Security system interfered with the free exercise rights of the Amish plaintiffs. Now, the Amish plaintiffs lost because the court said that right was outweighed by the government's interest in uniform applicability of the tax laws except as Congress otherwise provides. Well, there are two big differences between that case and this case. Number one, Congress has otherwise provided. Congress has said in the Religious Freedom Restoration Act, you must consider individual accommodations. It is not enough to say that it's a neutral law of general applicability. Congress has so declared. So that's the biggest distinction between this case and Lee. And the second is, this case does not involve the government's interest in uniform application of the tax laws. There is no question. There is a compelling overriding governmental interest in uniform application of the tax laws. The government could not function. If I got to say, well, I want to deduct 10% from my tax bill because I believe the war in Iraq is immoral, and Fred wants to take something out of his tax laws because he thinks some other policy is immoral, the government could not function.
Let me just ask one
Okay,
quick question, because I want to leave some
But
time
here the
for
government
questions.
has created exemptions, so it is not asserting that same interest.
I just want to ask one final question before I give it over to questions from the audience, and that is there a narrow way out of this? Is there some way that the court can rule that does not give RFRA an expansive application, but at the same time prevents, gives some sort of something to the people who are asserting this religious right? Is there some sort of way? I'm thinking of the first healthcare challenge, right, where the court avoided this, ruling that the Commerce Clause was expansive but still somehow allowed the law to stand in place. Is there something that can happen here in a similar way? Anybody?
Well, yeah, I think it may well be likely that the court avoids any dramatic pronouncements. I mean, they're going to be very nervous. This is an application for an exemption that comes from a very mainstream religion and a long tradition on contraception, a religion shared by 6 members of the court. But the consequences of a holding of exemptions go way beyond that. I mean, there's enormous consequences for the gay and lesbian community, religious objections to complying with anti-discrimination laws, for example, as we saw in the debate over Arizona. The court's going to be thinking about taxi cab drivers whose religious belief is that women should not appear outside the home without a male guardian, refusing to pick up women passengers, and whether you can still have your taxi medallion if you refuse to pick up unaccompanied women on the basis of your religion. There's a whole range of things. I mean, the easiest thing to do is to say there simply is not a mandate here, and we don't see that there's a burden from choosing not to have health insurance, number one. And number two, just to say that in this case, the transfer of the burden is so substantial to third parties that we're not going to recognize a legally cognizable substantial burden where the transfer to third parties, in this case the employees, is so great.
Again, because there are 2 types of plaintiffs, they don't ever have to reach the question of whether corporations have free exercise rights. They can rule simply on the owners of the corporation's claim. I think they can make it easier and say, well, there's no clash as for Plan B and Ella. There is no clash. There is no burden at all. And so this case should have been dismissed earlier, but that will never happen.
I think that if the Hobby Lobby plaintiffs win, it would be because the court, I think I agree that it's easier to say in the unique circumstances of this case these closely held family companies, not that they have rights, but these individuals don't wholly forfeit their free exercise rights by choosing the benefits of incorporation. And we're not going to make any broad pronouncements on how compelling the government interest otherwise would be, but given the exceptions and the exemptions are already there, it's hard for the government to maintain the compelling governmental interest. If the Hobby Lobby plaintiffs lose, I think that they would be most likely to lose on the question of substantial burden, because I think that, look, there are arguments on both sides of all these issues. I think it's harder for the court to say, given the exemption, there's an overriding interest, but it's easier for them to say, I can't really lay out the argument that the burden is not substantial as a matter of law. I mean, I think that's probably the easiest path for them to take to uphold the government's position.
What do you think, Fred?
I think if the government prevails, it's most likely to be the court finding that the burden in this case, that is avoiding the burden on third parties, on non-beneficiaries of the exemption, is too great to justify a REFRA exemption. There's already several cases, including one case interpreting Arlupa, which is a closely related statute to REFRA, in which the court repeatedly emphasized the need to balance the accommodation of religion against burdens on third parties.
That we'll open it up to questions. I see some of my fellow media members here, and so I'm going to give them the first dab at it. I think there's a microphone that's being slid around. Over to Ariana.
I have two questions. One to Caroline. I don't understand your talk about there being no clash, because it seems to me that the government concedes in its brief that while they don't buy the abortion-causing language, that that some of the drugs could prevent implantation. So that seems like it's, when you say the science isn't there, the government is conceding that, and that I don't understand that. And then I guess my second question is, well, I don't understand. We'll start with that one. Let me get to the second one. Oh, wait, here it is, Walter. Why doesn't the government spend more time in its brief on this note that, look, this isn't a mandate? They don't seem to spend a lot of time on it, particularly when Clement goes on and on and on about the fines. Those are my two.
I'm not representing the government. I'm saying, separate and apart from whatever position they may or may not have taken on it, the fact of the matter is these pills prevent ovulation, and so even according their belief that abortion is a sin and that killing a fertilized egg is an abortion, that is not at all what goes on with these medications. And so even from their point of view and their religious beliefs, these pills don't do what they think they do. And therefore, there is not actually a religious problem for them.
I have a question. I have a science question. I thought something like Plan B had a double effect. I thought it prevented ovulation, but it also meant that if you happen to have just ovulated and it's too late to prevent it, that it prevents the implantation. Is that not true? Okay, interesting.
Yeah. So when the pills were initially approved, that language is on the label because the initial studies were looking at whether they were effective, not how they worked. So they didn't actually know the mechanism, the precise mechanism at the time they were approved. But since then, there have been a whole slew of studies, and they're conclusive in terms of Plan B, that they prevent ovulation. And in fact, in Europe, they have changed the label to reflect this science. And
so if you've already ovulated, Plan B doesn't work. What about that other drug you were explaining to me before?
But they object to other contraceptives as well.
Again, their objections are to Plan B, Ella, and IUDs. And I've been talking about the morning after pills, which are Plan B and Ella. The science, I'm not as clear. I haven't looked into the science of IUDs. But in terms of, and I read somewhere there is some question about exactly how they work as well, right? But in terms of the morning after pills, the egg never leaves.
Well, given the confusion about the science as to how the IUD works, wouldn't you be entitled to a sort of objection against it if you thought it prevented implantation?
So there shouldn't be so much confusion about the science because scientists have filed amicus briefs explaining very clearly that this is how these pills worked at the Court of Appeals level as well. So this information is not secret. It's actually well known among reproductive scientists.
I understand theoretically that you're not entitled to your own facts. So if you object to working in a munitions factory, as the workman's compensation plaintiff did in Sherman against Werner, if it turns out that they're making toys instead of munitions, you may not have a well-founded objection, and that's Professor Corbin's point. I think here it doesn't get you very far because there are all these cases out there, and some of them are by people who object to all methods of contraception. Now, the court is not going to decide these one at a time, depending upon what particular methods a particular company objects to. They're going to make one ruling on this, so that at the end of the day, they're going to be ruling in anticipation of the cases where there's a religious objection to any form of contraception being covered, whether or not it results in implantation. And they're entitled to say, we think there's a remote possibility that even oral contraceptives have a secondary effect if they don't prevent ovulation of thickening the mucus in the endometrium and at least retarding implantation. So I think the point is not, it may be well taken, but I think it's not going to be decisive. On the question of why the government does it, the government has an interest in employers. One pillar of the program is that the government is relying upon the existence of a private system of employer-based health insurance. For historical reasons, that's the route this country took, after World War II, providing benefits in the form of health insurance compensation through employment. They think that's an important pillar of it as a policy matter. So I think the government doesn't want to make a great deal of the fact that employers really have a choice. They don't want to be talking employers out of the system of health insurance. But if you go to the final paragraph of the government's final brief, or the penultimate paragraph, they clearly state the point as a factual matter.
But the point is that it's not a mandate because you can choose to incur the penalty instead. Is that the point?
It's not a penalty. It's
the tax.
That's right. That's right. It's a tax on those who, with the amount of the tax, everybody agrees is significantly less than the cost of providing health insurance for employees.
Everybody agrees to that.
But okay, so I guess
There's no dispute over that. There's a different issue about if you have a policy that chooses to have a policy but it doesn't comply. They're very heavy penalties.
Yes.
But they're not heavy penalties if you choose not to have health insurance.
I think another problem, though, is it doesn't solve all the cases because a number of the claimants, I think even Hobby Lobby, but a number of the claimants have contended that the religion prohibits them from participating in contraception access, but also requires them to offer health insurance to their employees. A number of the Catholic plaintiffs in particular have argued that under Catholic social theory.
That's a really important point, and the fact is that the Catholic Church has been equally as strong in its advocacy of workers' rights and fair compensation and covering things like health care as it has been in its position on birth control and abortion. And so the answer to the question really is, it doesn't solve the moral problem because you're saying to the employer either pay a penalty financially if it really is more, or surrender what you regard as your perceived moral obligation to provide this coverage.
This is almost a newly invented idea, because if you choose not to have health insurance at all, then your employees are entitled to the federal subsidies in the market. You can increase their compensation, entitle to federal subsidies. They will get health insurance in that way. So the idea that there is a a sort of an established religious belief that it's important to provide the insurance coverage through the employment basis rather than through the subsidies in the market it's going to be hard to find that assertion predating this issue.
Well, let me say, it probably requires an analysis, a factual analysis beyond what we can do here, and it probably requires a trial.
And what we can do is ask another question. Does anyone else from the media have a question, or can we open it up? Okay, let's open it up.
Yeah, Janet Adams from the Wall Street.
Can we wait for the microphone? Oh, sorry.
Hi, Janet Adamy from the Wall Street Journal. I did want to come back to this point and clarify just on, you were talking about the burden and the penalties. Am I correct in understanding that what the plaintiffs are arguing is that they would face a penalty for their plan not complying? Like the argument that they're making is that they would have to pay millions of dollars if they didn't include, if they didn't have an exemption, if they were to exclude this contraception, that they would face fines of millions of dollars for not including the contraception, not that they would face a fine. They're not presenting this as the alternative being that they would drop their plan altogether. And if I'm understanding that correctly, that does seem like it's a fairly significant burden. So I'm wondering if the folks who are discussing this idea of, well, they may not be able to show the burden, wouldn't a fine of millions of dollars be a fairly significant burden?
Yes, it would. That is a fine. Those millions of dollars of fines apply if you choose to offer a health insurance policy that is not in compliance with the requirements of minimum coverage. If you choose not to offer health insurance at all, which you're free to do, you have to pay an assessment that is far, far less than that. Indeed, far less than the cost of providing health insurance. Is that clear? So I agree, there's not an option to have an insurance policy that doesn't include contraception. Because there, if you do that, you do have to pay the millions of dollars. The alternative, the reason it's not a mandate, is that you can choose not to have health insurance at all and pay a lot less and save yourself some money.
Then you have to pay significantly higher wages because you've got to basically give your employees enough after-tax money to purchase this rather than taking advantage of the ability to buy health care coverage with pre-tax dollars.
One of the problems is they haven't pled that as a burden in these cases on the pleadings. There's no pleadings that set out why that is a burden, and that would be, I mean, if the court really wanted to be narrow, they could say, you don't meet the pleading standards. You say vaguely in your appellate brief that we believe we would be at a competitive disadvantage if we didn't offer health insurance, even though we would have the funds to pay higher wage compensation. We believe we'd be at a competitive. You never pled why that's really a burden. There's no sufficient specificity there to challenge the constitutionality of a program if that's your only burden. So that is an answer to the question that you asked as to whether there's a narrow way out. It's on that can be a burden, particularly in contrast with the burden on employees who are denied contraceptive coverage.
Right. We have time for one, maybe two questions if they're quick. Right up here. Oops.
Hello, Jessica Ahrens, president of the Reproductive Health Technologies Project. I have a question for Mr. Baine. When you're talking about these other policy solutions and the fact that this could be more narrowly tailored, or that they could extend the exemption, the accommodation to these for-profit corporations, and the insurance companies can just directly cover more employees themselves. What if these plaintiffs were to win in this case? What prevents the insurance companies from then asserting free exercise claims? Their corporations, perhaps some are owned by closely held. Then they come back and they say, well, we don't want to have to comply. So again, we're back to the government, where some people might assert a taxpayer right not to have to subsidize contraception. So where do we go?
Theoretically, what you outlined could happen, but this situation has been out there for about a year now. I'm not aware of any insurance company saying we have a problem with this. In theory, closely held insurance company, I suppose, could say that, but that closely held insurance company would probably have a hard time selling much insurance.
Well, there are Catholic-affiliated HMOs already getting federal exemptions under something called the Weldon Amendment in terms of referrals and things like that, and coverage for abortion care. You could see that principle being extended. So there are precedent.
I'm not an expert on insurance, so I'll caution you on that. But if these Catholic HMOs or whatever that you're referring to, I suppose already don't provide this kind of coverage and wouldn't be providing the coverage to these kinds of employers at all, I would suspect, but I don't know the answer to the question.
Last question on the way back.
We got it. Okay. Ian Milheiser with Think Progress. Kevin, I understand your argument that you're saying it's not a compelling interest if the government has already created other exemptions because that constitutes a concession. I've read the Ocentro case as well, so I know that there's some case law support for that. But it seems to be the problem with that is if that argument wins, what the White House is going to do the next day is they're going to go through every single regulation that has a religious exemption in it that's been tailored so that it exempts the people where they thought it would have made sense and doesn't cut too broadly. And they're going to delete that exemption. And the reason they're going to delete that exemption, and Congress may come around and delete the religious exemption from Title VII as well, and the reason they're going to delete that is because the rule that you're describing is a rule where we can't have tailored religious exemptions. We can either have one that lets in every possible religious exemption, or we can have a rule where there's no exemption and there's no middle ground in this rule you're laying out. So, I appreciate that there's some legal support for it, but given that I think if the government's forced to choose between those two worlds, they're very frequently going to say, well, we don't want a religious exemption at all. If I'm someone who cares about religious liberty, why on earth would I want the regime you're describing?
Well, I appreciate the question for a couple of reasons. One, it kind of underscores an interesting point I was discussing with Walter beforehand. The whole idea that the government should accommodate religious liberty was a liberal idea. It was the dissenters in the Smith case were the liberals. It was Brennan, Marshall, Blackmun, and Justice O'Connor who felt that the Free Exercise Clause demanded these accommodations from neutral laws of general applicability. It was the conservatives who said, no, if it's a neutral law of general applicability, that's the end of it. So it's interesting to kind of underscore, I think, that the idea of accommodating religion is a liberal progressive idea, not a conservative reactionary one. So I agree with you that you should ask yourself, well, does this mean the end of religious accommodations? And I'm generally not one that says, well, anytime the government goes this far, it's got to take the next step. The government can make rational decisions and decide how far a policy extends. But I think in this particular case, the reality is that when the government made the second concession, not the first one which exempted the religious employers, but when it said, you know what, even employers who aren't exempt under the law, we want to accommodate religious values, I don't see that the government has really said that where religious values exist, we want to accommodate some but not others. The government instead has said we don't think there's a religious interest here at all. And I think that if the court said, well, there is one, I don't know what the Obama administration would do, but I don't think they would erase the existing accommodations. I think they would say, gee, if we got this wrong and there's a really sincere religious exemption, we're in favor of those things, so we've taken it this far, we'll take it a little bit further. Because, again, the logic of the position that we have in the brief is not that every corporation in America can assert a religious exemption. It'd be probably pretty hard to make the showing that the individuals who founded the corporation founded on these religious principles. I don't think you could simply come in and say, well, I'm the CEO and I'm a member of this religious tradition and therefore my company is not going to do this. It'd be a hard case.
I think Walter gets the last word.
Yeah, the idea that health insurance include preventive services, including contraception, is not new, it's not novel, it's not unprecedented. It became an issue when it was part of something called Obamacare. We've had this, as I said earlier, in 28 states have had requirements that insurance policies encompass one or more forms of coverage for contraception, and no one raised that as an issue. And the reason they didn't is because of the critical role of intervening private choice. That nobody uses contraception unless the individual chooses to use contraception on his or her own. That's sort of the circuit breaker. That's why I've always supported allowing religious groups to use general funding for religious purposes, because there's a citizen that decides they're going to use this benefit for religious purpose. That's the circuit breaker. And here, it's the individual woman who consults her own moral beliefs, her own religious tradition, her own conscience, her own needs, that decides what to do here. And that has never been controversial. That has been covered as part of insurance packages required by state insurance law, for a good while. It's only new and controversial when it's part of Obamacare, apparently.
Well, I think the panelists, join me in thanking the panelists for this very interesting discussion.